you can't put, oh, I want all these different stipulations in a will, which only controls probate, and then say, oh, well, I'm going to avoid probate and do these beneficiary designations and still expect all of those restrictions to be there. That's just not how it works. Hi, Jeff Mersace, the Plain English Attorney, and we're going to react to a post from Reddit r/estateplanning, and this is coming down to a big fundamental misunderstanding of what a will controls. And while I can only speculate on the actual outcome based on the discussion and the input from attorneys, it sounds like the person who's posting it isn't really clear on this one point. So let's go ahead and jump right into it. Kentucky Will and Testament Survivorship question. My family member mentioned his child and siblings by name, but he also put in his will a part that says, if any individual designated as a beneficiary under this will fails to survive me by 180 days, then for all purposes of this will, that person shall be deemed to have predeceased me. One of the beneficiaries passed away a few weeks after the will holder, and his beneficiary claimed his portion of the estate. Does this prove it should go to them, and is there something that can be done about it? All right, so that's the first post, but as you're going to see very quickly, it gets more confusing. Let me see if I got this. Alex died, and his will named Bobby as a beneficiary. But then Bobby died within that 180 days. So you want to know if Bobby's beneficiary, who is Charlie, can get part of Alex's estate. Is that correct? I would think not. Anything in Bobby's will is irrelevant as far as Alex's estate goes. So we're talking about Bobby having a will. All right. And so the poster comes back with, yes, essentially. The financial advisor over Alex's assets wrote up paperwork and granted Bobby's beneficiary Bobby's part of Alex's estate. But if I'm understanding the will correctly, that's not what it's legally giving permission for. Okay, so wait a minute. The financial advisor over the account is giving it to someone else.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Then it's the financial institution that has a hold of it, not the court. Which means it's not in probate. It's the financial account that's going to that next person's beneficiary. So it's not the person who died who said maybe, all right, I want half to go to my child and I want the other half to go to my siblings. And in their will, they put, if anybody passes on within 180 days, then their share is treated as if they predeceased them. Two big issues here. If it's Bobby, that sibling, who died, and in the will it says it goes to these siblings per stirpes, then Bobby's beneficiary may just be the child that Bobby had, which is the same exact thing. If it's going to siblings equally per stirpes, then it means if a sibling dies, their children take whatever their share is. So what if Bobby had a will that said that? That's not what we're talking about. We're talking about Alex's will in this example. But if that account isn't even in probate, and the account says it goes 50% to the child, 50% to the siblings, equally per stirpes, then what's in the account controls? And we're going to see that as we move a little bit further along. Yes, they gave control. They legally don't have permission. Whoa, wait a minute. I don't have the exact words of the wills, but it seems to me that Bobby's part of Alex's estate equals 0. Bobby gets nothing because Bobby was dead as far as Alex's estate is concerned. Now, that would be correct if there wasn't the, quote, per stirpes language, and if it were in probate. But if the account said, no, 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 if Bobby survives at all beyond Alex dying, then it goes to Bobby's next of kin or children or beneficiaries or whatever's in the contract. So the important point, the important distinction here is, look, if it's not in probate, the will has absolutely no control. It goes according to what's in the contract for that account, stock account, annuity, whatever. It's controlled by the contract between Alex and the financial company handling his investment. And, okay, it's possible maybe all are part of some of the settlement agreement among the beneficiaries. Does this affect what you get? If not, then you don't have legal grounds to complain. All right. Oh, and as for this financial advisor, who is he to Alex's estate? Is he the estate person? So that's the point. Is it's probably not in the estate. And the quote right under that, financial advisor, makes me think this financial advisor could be handling accounts with named beneficiaries. Any account with a beneficiary is not part of the estate. The will has no effect over those accounts. You need to clarify this to get better answers. And that's the 100% truth of it. You need to have clarity on whether this is in probate or outside of probate. But this is something that happens, and I have a video on it about the disjointed will plan. It's, okay, well, I want everything to go to my kids, but I want to have an age limit in the will of 30, and yet they name the kids directly as beneficiaries on the account, and then everybody starts screaming when at 22 years old, little Timmy inherits $300,000. It's like, but the will said 30. Well, no, you put the beneficiary designation. It doesn't matter what the will says. It only matters what's on the account, and those accounts, typically it's 18 or 21. You're a legal adult at 18. Some institutions say, no, we're going to set it at 21. Fine, you signed up. You put your money in with them. They get it at 21. But the will says the will doesn't control it if it's not in probate, and that's the big distinction here. All that should matter is what the will says would have happened to this share of property if this person had died before the testator. Unless the will is silent on this issue, which equals poorly drafted will, that is your answer. Well, that would be the answer, except a lot of this is starting to sound like it's not even in probate, so the will has zero effect on it. The original poster. I totally understand that, but a financial advisor granted them the portion of the assets, and I didn't want to bring anything up if there wasn't cause to. That's the thing, is there probably isn't. Now, oh, this financial advisor, we should take this to court. Well, let me tell you something. When someone dies, and there's a significant account, and it's going to named beneficiaries, it's not just the financial advisor saying, oh, well, I feel like I should do this. If there's any question at all, it's immediately looked at in their legal department because they are contractually obligated. Again, contractually obligated to get it to the right beneficiaries. If they give that money to someone else, they're on the hook to pay that money to the correct beneficiary. So you don't really see financial institutions getting these calls wrong all that much. So, again, I haven't seen the will, I haven't seen the beneficiary designations, I haven't seen the contract. But if the contract said, here's where it goes, that's where it goes. And this guy keeps going back to the will, and it's just not, it's not appropriate. You didn't answer my question. Is his beneficiary the same person who should have taken under the will. And that's the example I gave is, well, if Bobby died and it's Bobby's child and it's a, quote, per stirpe situation, meaning if someone dies within that time frame or before you, it goes to their next person, their next of kin, usually children. All right. Under the way this is being phrased makes me wonder whether this isn't an asset with a designated beneficiary under management of the financial advisor, survivorship under a will versus under a beneficiary designation might rightly have two entirely different answers. Completely 100% accurate. It could be two completely different answers. What's the beneficiary under the will and what's that contingent beneficiary under that account can be totally different things. Yes, it was stock, so that might be the case. They followed the will to divide up the assets, though. The money was itemized in it. All right. If it's, quote, itemized in probate, in North Carolina, there's the initial inventory. And the initial inventory says you have to list all of these accounts, whether they're actually in probate or not. All right. Given the benefit of the doubt, maybe it did say that the pay on death beneficiaries to avoid probate are the same as under the will, and it referenced the will. Even if it referenced the will, that doesn't mean it follows probate procedures. The contract might still say if a beneficiary dies within 30 days, and that's a lot more common than 180 days. Within 30 days, okay, it's going to end up going to their, if it's after 30 days, it goes to the next of kin. It doesn't get thrown into probate. It doesn't get controlled by the will. It doesn't go necessarily to the estate if the contract says here's who the beneficiaries are. All right. If the stock was held in a brokerage account, then the contract with the brokerage company trumps the will, generally. Well, and I'd push a little further and say almost always. The beneficiary form on file with the company is part of the contract. In other words, the company doesn't care what's in the will. It just follows the contract. And then under that same, sounds like a my descendants per stirpes designation, since it isn't going to initial beneficiary's estate, meaning probate. If it's, again, under that contract, they're exactly right. And now the poster again. His beneficiary was already named in the will holder's estate. Okay, so his beneficiary was already named in the will holder's estate. So Alex, again, that's the example. Alex died and it said it goes to Bobby. And if Bobby dies, then before I do or within 180 days, then it goes to Bobby's kid. Well, if that's already in the beneficiary designation, it just happens that these plans are lined up, which is the way most of my clients that do wills will do it. Most of my clients actually use revocable living trusts. The will states what I quoted in my original post. I was trying to get clarity on what exactly that meant. And here we go. This is very clear. You're still not understanding. There are only two options here. And these, quote, two options are dealing with this particular account. The property is passing under the will. Then all that matters is what the will says happens to a beneficiary's share of property if they fail to survive the testator. 2, the property is passing outside of the will. The will is irrelevant. All that matters if the named beneficiary under the beneficiary designation for such account fails to survive the account holder is what the terms of the contract say and or what state law says happens in this situation, are we under number 1 or number 2 here? That's exactly it. Was it in probate or wasn't it? Again, it's getting back to that previous video I did, the disjointed will plan. You can't put, oh, I want all these different stipulations in a will, which only controls probate, and then say, oh, well, I'm going to avoid probate and do these beneficiary designations and still expect all of those restrictions to be there. That's just not how it works. And look, this last comment just kind of wraps it up if you're that confused. Look, petition the court for instructions. Why would you want to unilaterally deny a claim when there's a way to shift responsibility on someone else? And that's it. If you get the court to say, here's where it goes, that's where it goes, but you're dealing now with court. Now, most of my clients were using a revocable living trust, and we're recommending you put the account in the trust. This way, there's none of this disconnect. Was it in probate? Was it not in probate? How did the contracts? No, look, once it's in the trust, it's owned by the trust. All of those terms kind of take over when it comes to who gets what, when do they get it, what are the ages of inheritance and whatnot, because the trust doesn't die. So that ownership is in the trust. The person who set up the trust, they died. But now the trustee steps in and they take that money out and distribute it. It's not in any period of transition from the account to the trust because it's already there. And now all of the questions get looked at in the trust. So you can now say there's an age limit of 40. They only get so much at some point, and well, if this person dies, then here's where it goes and here's how it goes. It's all explained in the trust. You don't have this quote disjointed will plan. So I hope you found that entertaining and I hope you found it useful. Check out that video on the disjointed will plan. As I always tell to my clients, look, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.